For our session today, we have a personality who has more than a decade of experience
Siddharth,
of.
you are not audible.
Uh, 1 second. Hold on. Is this better?
Yes,
Yeah,
Siddharth, I could hear
yeah,
you.
yeah. You are
All
audible.
right. Mr. Singhal, am I audible?
Yeah, absolutely, loud and
Okay.
clear.
Thank you. Yes, so today we have a personality who has more than a decade of experience of working with various organizations such as BMR Associates and the Big Fours, KPMG and Ernst& Young. With a career spanning over 19 years in corporate and international taxation, the feathers to his cap are numerous. He is none other than Mr. Gaurav Singhal, co-founder of Saksham Ventures and Heads Up Consulting Private Limited, which is a knowledge enterprise and a professional services firm, respectively. Sir has been nominated as a special invitee of the Committee on International Taxation of the ICAI for the year 2021 to 2022. Uh, Sir is a regular speaker in several seminars organized by different forums such as ICAI, IFA, PhD chambers, and so on. Sir is also frequently invited by companies and law firms to train their employees on domestic and international taxation. So we're truly elated to have you with us. And we also have with us Ms. Kriti Chawla, who is a professor at Jindal Global Law School. And I welcome you, ma'am. So without much ado, I now request Gaurav sir to actually enlighten us and walk us through his article titled Capital Gains Tax on Intangible Assets. I also request all the participants to kindly, if you have any, post your questions in the chat box and we'll address them at the end of the session.
Thanks, Siddharth. Thank you so much. You have been too kind with your words. Plus, the way you loaded the entire, introduction with "sir" so many times, reminded me how old I'm getting. So just to sort of wriggle out of that, I suggest you that you all of you can call me Gaurav. That's what I'm more accustomed to. Um, just confirming, are these slides visible? I'm going to be using them for only the initial 15-20 minutes to give you an outline of the discussion topic, and then we'll throw open the platform for your questions. Kriti, are the slides visible?
Yes, they're visible.
Yes.
Thank you so much. Thanks. So, why are we talking about capital gains on intangible assets? Because while I know that you guys, the budding legal luminaries, right, are more accustomed to talking about intangibles in the context of patent, copyrights, etc. But I'm also aware that you guys are aware about the new age intangibles, and those new age intangibles are the ones which are getting the valuations for which are getting crazier by the day. So before I directly load on to you the crypto valuations and the NFT valuations, even before the whole thing started, just look at what happened in the context of an MMORPG, a massively online multiplayer online role-playing game, which is essentially Entropia, on which a planet. Now, this is a virtual planet. This is not a solar planet. This is not an exoplanet. This is a virtual planet called Calypso, which was sold at the valuation of $6 million. And now look at it in contrast to something which has happened very recently in comparison. The most expensive NFT which has been sold till date, and this has been sold by Christie's, if I recall correctly, and this is their first NFT art sale, and actually value-wise speaking, one of the topmost art sales ever, right? And this sold for 69.3 million. But it was made by a gentleman who is a digital art celebrity, Mike Beeple, and we have the examples of the tweets getting sold for 2.9 million. Remember the Charlie Bit Me video, right? The Charlie Bit Me video got sold for 500,000 pounds. You have another example in which the single largest Bitcoin transaction, which happened last year in 2020, it was for an approximate value of $1.033 billion. Mind you, nobody knows who was the person who entered into the transaction and why did he move those many number of Bitcoins in one single transaction. Is the point that I'm trying to make, is that it's not just individuals are working upon it. Let's look at the other side also. Decentraland, right? If you're not aware of the concept, Google it up. It's exciting. So, the heaviest real estate, but mind you, a virtual real estate deal, which happened again last year on Decentraland, was again close to $1 million. And this time, the buyer was a digital real estate investment fund. I repeat, it's not a real world real estate investment fund. Instead, it's a digital real estate investment fund. So the businesses are sort of positioning themselves in a fashion where these transactions are being sought after by them, right? When you're talking about these transactions, naturally comes the question of their taxation. And the common thread amongst all these transactions was that the asset is an intangible. Now, when we are talking about intangibles, why is it that the taxation of intangibles is so relevant for you and I to talk about, for us to understand, is that more often than not, you'll find that the valuations of intangible, they are sky high, and that's the reason why the tax, quantum, if any, is also equally high. When we talk about intangibles, it's not surprising that the legal clarity, and I'm not talking about the tax law, I'm just talking about the law which deals with intangibles. And and a number of times there is no law which deals with those intangibles. It's either missing or it's unclear, right? And different countries follow different positions as regards taxation of these intangibles, which allows an arbitrage opportunity to people who are dealing in intangibles. Uh, we all know that the whole concept, the whole theme of BEPS project was stemming upon 3 4 features. One of them was the absolute mobility of intangibles, and how that actually is used not just in digital economy, even otherwise, but fundamentally in digital economy, to maybe shift profits. As a result, when you will be really out there in the field, in the practical world, you will find that you have both the angels and devils sitting on your shoulder, and both of them telling you that the scope of tax reduction, whether legitimate or avoidance, is really wide when it comes to planning as regards IP, as regards intangibles. So that's the reason why the theme for this discussion is going to be centered upon the taxation aspect of intangibles. But after all, intangibles are assets, right? So when we talk about taxation on sale of intangibles, taxation on transfer of intangibles, why don't we start from the very basics? That forget about the fact that they are intangible. Even if we talk about a tangible asset, how is it that a tangible asset is taxed when it is sold? And the answer is that you first of all characterize whether that asset is an investment asset or is it an inventory. Because if it's an investment asset, then uh, most of the countries, such as ours, like India, we tax it under the head capital gains. We tax it at the rate which is a somewhat lower rate, which is applicable to capital gains. Some countries, again like India, they allow you an inflation adjustment. And then there are, of course, other countries, Singapore, for instance. They say that fine, it's capital, it's an item of capital gain, but we don't opt to tax it anywhere under our domestic law. If that asset, however, is a stock, it's an inventory, something in which you deal on a day-to-day basis, then of course it's business profits, and that's where it becomes relevant for traders. With this background, let's look at what are the domestic tax law provisions which deal with taxation of assets in specific, in particular, intangibles. And the charging provision for taxation of capital gain is good old section 45(1), which says as long there's a capital asset, as long as it has been transferred, that is sufficient to trigger a charge against the gain that may have arisen from this transfer, and therefore it will be taxable under the domestic tax law. But what is capital gain? Now, interestingly, it's actually not defined anywhere, not really in the domestic tax law, not really in the tax treaties, not in the mutual conventions. It's essentially the gain upon transfer of capital asset. That's how it is, right? Uh, which means that different countries may end up defining uh, capital gains under their domestic tax laws differently. And you already know the principle of tax treaty interpretation, that if an expression, if a term is not defined in the treaties, then it takes up its meaning from the domestic tax law in respect of which it is being measured, in respect of which it is being evaluated. Which means essentially that in the context of the country of ours, when we look at any of the tax treaties and try and figure out that is capital gain tax going to apply upon transfer of an intangible, is it even capital gain tax, then the answer to those questions have to be first looked into the domestic tax law, and then we move towards the treaties. As a result of which, what we will do here again is also look at the domestic tax law. That brings us to the question that fine, for if you're a resident, then your global income is taxable in India wherever arising. Therefore, for a resident who's selling an asset, an intangible asset, his income is definitely going to be taxable in India, no questions asked. Right? What about a non-resident? When is a non-resident's income chargeable to tax in India? And the answer to that is when it accrues or arises in India, or when it is deemed to accrue or arise in India. Now, Section 9 tells us that when is an income deemed to accrue or arise in India? And the answer that it gives is that when that capital asset, the one which is being transferred, right? When that capital asset is situated in India, so it's a question of location, location, location. If the asset is located in India, the one which is getting transferred, then the fact that the seller is a non-resident makes no difference. At least under the domestic tax law, the income which has been earned by the non-resident upon selling this asset, which is located in India, will be taxable in India. The fact that he receives it outside India, again, makes no difference whatsoever. Now, come to think of it, was this not really the provision which triggered one of the largest international tax battle in the history of the world, really, right? And that is the Vodafone battle. That is the one which resulted into that whole retrospective amendment budget of 2012, the repercussions of which we are seeing as late as now, right? And the government has been coming up with the ordinances to sort of, set the record straight, remove the retrospectivity aspect of it. So where did it all start? Again, the question was the same. The question there was also, fundamentally speaking, about some kind of an IP. It's just that it got twisted around shares. The question was that the Indian revenue authorities were saying that, look, while these shares of a foreign company have been sold, still the resulting gain will be taxable in India. And why? Because those shares are deriving their value from a business which is located in India, from control of that business which is located in India. And what is that control if not an intangible, right? So that if you think about it, even the Vodafone controversy was at some level talking about some kind of intangibles. But I will not take you towards Vodafone because I know I'll be putting you to to the dream world. You must have heard about the Vodafone controversies from zillions of other experts. So let's come back. When we talk about intangible assets, well, there is a definition, but there's no point looking at it because really it's really not in the context that we are talking about. So what kind of intangible assets will form part of the definition of capital assets? And answer is, well, all kinds of things, right? All kinds of things. Because the courts have held that the capital asset, the expression capital asset, the way it has been defined, it starts by saying property of any kind which is capable of being held. And that's it, right? So the courts have held that, look, are you listening to it? This is such a widely defined expression. So every possible interest which can be acquired, held, or enjoyed, well, that is a capital asset. And therefore, even intangibles are capital assets. So no doubts about that. What I will tell you now is something which is, let's call it my philosophy, right? When we talk about intangibles, I would say that there are, well, three kinds of intangibles. The first one are the classical, traditional intellectual property rights, patents, copyrights, trademarks, right, brand name, and so on and so forth. And for that, there is hardly any doubt that they are capital asset, and therefore, when they will be sold, some gain will, whenever some gain will arise, it will be taxable in India. But the question will be that when they are being sold by a non-resident, when will you say that those intangibles are situated in India? And that's a question we will circle back to when we'll be discussing about a few decisions down a few slides. The second category of rights. Now, these are intangibles, which are not the kind of rights that you can register, for instance. For example, in the context of patents, you can register them, you can sort of protect them. But these are commercial rights, which are just transferred between businesses. And we see we observe those kinds of transactions happening in a ton of BTAs, business transfer arrangements that we are looking at. But really speaking, you don't find themselves registered like a patent or a trademark is, right? And these can be, for instance, licenses. They can be transfer of customer data. There can be a toll right? So on that, again, when the question traveled to the courts, that, hey, are these capital assets? The courts have held different views, but more often than not, what we find is they lean towards saying that if these are, for instance, toll collection rights, they are capital asset. And yet, it is a highly factual analysis, not a purely legal analysis. It's a highly fact-based outcome. So therefore, you might come across situations in which there is a licensing of an IP from one to another, And you might tell me that, Gaurav, come on, the action plan 8 to 10 report of under the BEPS project says that, hey, licensing is also a kind of transfer, but it says that it's in the context, it's in the context of transfer pricing, otherwise not, right? So therefore, some kind of licenses may qualify as transfer perhaps, but other kinds might not, right? And then the third category of of the new age jazzy snazzy intangibles, the world of digital tokens. What will happen to these? Will they be treated as capital assets or not? I have my views and I will share them, but the government has yet to come out with its own. So the jurisprudence so far, well, the court has held that goodwill is an intangible asset. Mind you, the income tax definition of intangible asset for the purpose of depreciation says it's not, but for the purpose of depreciation. For the purpose of capital gains, it doesn't say anything. It's actually silent. As a result, when goodwill is sold by a business to another, well, capital gains can arise and therefore they might be taxable. Similarly, we were talking about the toll collection right, again, an intangible asset. Therefore, if it is transferred, can result in capital gains. So when can we say that an intangibles, again, say such as a crypto, if you are into crypto, investment or trading, when is it that a gain earned by you be eligible to enjoy the capital gain tax treatment, which is, and I'm saying enjoy because if you have been holding out for sufficiently long, and then you have sort of sold it and made a ton of money, then firstly, party, right? But secondly, you get a lower rate of tax and an indexation benefit, inflation adjustment benefit. And when would it be that the Indian tax authorities will say that, hey, no, we will not give you those benefits. They'll be taxable as your business income, which is taxable. Well, in terms of rate, at the normal rate of tax. You would find that this is perhaps going to be one of the most common controversies in coming years, looking at how India has handled these issues in past. For instance, when it came to shares trading, this issue has not died down ever. Whether income from sale and purchase of shares, is it income out of that capital gains or income out of that, profits and gains of business or profession? And the reason is that it can be either. It can be either. It depends upon what's your intent when you are investing into those shares, and that intent is something which can be sort of deciphered, can probably be figured out or decrypted, no pun intended, from the number of transactions, the frequency of transactions that you have over the year, the amount that you're investing into shares, the number of shares that you buy, for how long do you hold them, in which account do you get them, how do you account for them, do you maintain accounts for them, do you run this as a business systematic exercise, or do you do this as a vocation, one-off kind of transactions? These same principles are gonna be applied even in the context of the new age, digital tokens that we'll be looking at. This was about the domestic tax law. I'll now quickly tell you the core controversy, which is actually arising, which will actually arise because of the treaties, and that is because when we talk about the article, when we look at the article which deals with taxation of capital gains in tax treaties, we find that, not too surprisingly, intangibles do not have a unique paragraph of their own. They actually fall under the residual clause. So you have a clause which deals with immovable, you have a clause which deals with movable properties of, permanent establishment, you have a clause which deals with shares, and then you have a residual clause. And the residual clause, well, that clause includes even all those assets which have not been dealt with any other specifically expressly written paragraphs of that article. So, intangibles are also covered there, and that's what is a position which India agrees to. Jurisprudence is there in favor of us. But the interesting thing is that if you look at the treaties which follow either the UN approach or the OECD approach, the residual clause gives exclusive taxable rights only to the state of residence of the taxpayer and give absolutely no taxing right whatsoever to the source state, which I mean to say is that if there's an intangible which has been sold by a non-resident and the intangible is, well, said to be situated in India, then although the domestic tax law will have the right to tax it, the treaty will say that, come on, we are talking about intangibles and they fall under the residual clause, and as per the residual clause, the source state doesn't get the right to tax it. It's only the resident state which has the exclusive taxing right. So India will be denied its right to tax those gains, irrespective of wherever you sign the agreement for assignment of the intangibles, irrespective of who's the beneficiary of one of those assigned, irrespective of even the fact that while we are saying that the source state will not tax it and the resident state alone will tax it, it could be a situation the resident state doesn't bother taxing it in the sale of intangibles in its domestic tax law. As a result, I think it's a good point where we look at some of the actual tax treaties that India has with some of its important trade partners. UK, US, Canada, these are the treaties which are standing on one side of the spectrum, complete extreme of the spectrum, which actually favors the Indian exchequer, because they say that, look, we are not getting into that mess, which messy affair which has been created by the OECD or UN model in context of the capital gain clauses. We are just allowing both the countries to follow their respective domestic tax law, and we'll settle it through foreign tax credit. So therefore, nobody actually loses a big chunk of the capital gain tax revenues. On the other hand, on the other side of the spectrum is, for instance, Netherlands, which, as I mentioned earlier, follows the pattern of the OECD treaty and says that, hey, when you're talking about any assets which have not already been talked about elsewhere, such as the intangibles, then the taxing right will be given only to the resident state. Sweden somewhere builds a layer of protection that, fine, we are giving the exclusive taxing right only to the state of residence, provided the state of resident is actually taxing it, and it's not that it is getting doubly non-taxed, right? So which again brings us to the question, where is the IP located? And that's really something which is fuzzy, because it's intangible. You can't even see it, much less feel it, touch it. And the answer therefore is probably going to be where the legal owner is located, and that's what the Delhi High Court finally held in a decision in the case of CUB-PTY, which overlooked essentially a Foster's advanced ruling. In the case of Foster's advanced ruling, the advanced ruling authority was actually saying that look at where you are utilizing the IP. How much expenditure has been incurred on advertisements, etc., which have helped contribute towards the building of brand for Foster's. Therefore, we think that when you sell Foster's trademarks outside India, and you're not an Indian resident, still the capital gain will be taxable in India. But Delhi High Court said, no, we are reversing it, because we think that it's only the domicile of the legal owner which tells us where, which is a good approximation of where the IP itself is located. And why did they say so? They justified it by saying that, look, if the lawmakers, the legislature, wanted to take a position that we will deem that the situs of an IP is in India, where it is being utilized in India, they could have created a deeming fiction, just like they did for shares in the after the as an aftermath of the Vodafone decision, which is usually called the offshore indirect tax transfer provisions. But there's no such similar provision in the context of IP, and since there are none, we will go by the old age Latin maxim, which basically says that in the situs of the owner is a good approximation of the situs of the asset, and particularly when we are talking about a movable intangible asset. So these are the decisions, the Foster's advanced ruling and the CUB-PTY Limited Delhi High Court decision that I was referring to. Now I'll just quickly wrap this up and then throw open the stage for your questions, which I'm waiting for. But before that, just looking at the last crystal ball gazing exercise, that finally, what do we think? Where are intangibles, capital gain on sale of intangibles going to be taxed? Well, this is something which is a controversy which will live on, because even now the kind of guidance that we see is something which is highly subjective, and it's not surprising. It will remain, because we are dealing with intangibles. On one hand, OECD is suggesting that follow the principles of DEMPE, which is essentially look at the jurisdictions which are contributing towards development, enhancement, maintenance, protection, and exploitation of an IP, and find out what's their relative contribution, and that is where you will see that who should get how much of taxing rights. But the thing is, remember that Article 8 to 10 action plans 8 to 10 are really applicable in the context of transfer pricing controversies. That means we are dealing with only those kinds of cap gains which result because of transfer of IPs between associated enterprises, where associated enterprises are not the ones which are, the buyers and sellers. Instead, the transaction is between two different independent parties. Then probably the MPA function won't have any role to play, right? And yet, on the other hand, we have other sets of provisions. For instance, if there are people, if there are many groups which are using a highly favorable tax treaty to their advantage and placing an IP owner in a particular jurisdiction fundamentally and predominantly to draw the benefit of the tax treaties which that country has with its trade partners, then anti-treaty shopping clauses may kick in, or the principal purpose test if it has got incorporated through the MLI, that is if those relevant treaties are covered tax agreements, then the PPT test will also come and stand as a challenge to any such treaty shopping exercises. Time permitting, we'll probably talk about the divergence. We'll talk about what are the positions being taken by different countries when it comes to their position about taxation of digital tokens, cryptos, and so on and so forth. What's the status in India? Well, India's status is that initially we were confused. We were not even sure that do we want to treat cryptos as legal. At some point of time, there was a committee which said that, hey, all private crypto transactions should be treated as illegal. In fact, you know what? One of the recommendations in a draft law which they had sort of proposed, and thankfully it was never passed, was that there could be an imprisonment of up to 10 years for a person who's dealing in these private cryptocurrencies, right? But now things have sort of cleared up because at some stage the Supreme Court passed a favorable decision saying that look, there's really no harm which is happening. Why are you getting sacked out about it? And now what we see is that there's a shift. There's a shift where the government is sort of being open that it only wants to regulate it and no more than that. Taxation principles are yet to be cleared up. At least at the end of the lawmakers, that thing is still a gap. And the questions which will remain open is, as we discussed, whether these intangibles will be treated as stock and trades or investments. What will happen if suppose I'm an Indian resident, I buy a Bitcoin today, and then later on imagine I shift lock, stock, and barrel. I become a non-resident, and after becoming non-resident, then I sell the same very Bitcoin which I purchased when I was a resident. So we don't have the concept of exit taxes in India. So where will this capital gain be taxed? You would find some articles which talk about a levy of equalization, levy of EQL on cryptos. Look, presently EQL applies only to two natures of transactions. Online advertising, which is clearly not the one applicable here, or the second one is applicable to non-residents, which are essentially leveraging upon a platform to earn a particular income. So if we are talking about a crypto exchange, well, that's a digital platform, right? But if you're talking about traders, they don't have any platform of their own, so they're not going to be subjected to equalization levy. And then the next question will be, will there be a next version of equalization levy which will probably target it? And I will now pause and unshare the screen and wait for your questions, everybody.
Thank you so much, sir. That was a very articulate and riveting speech. It was indeed an insightful session, and I'm sure it was a great learning experience for all of us who are attending the webinar today. So I would now request to anyone to post their questions if they have in the chat box, and we'll be taking the questions.
I think there was actually a question sent in the chat box by Sahil, which was, can we claim depreciation on goodwill if goodwill is taken as a balancing figure in amalgamation?
Sahil, good question, and that's a controversy that we guys are debating since several days, and particularly since this morning. Look, it's a bit of a murky affair. At some point of time, the Honorable Supreme Court came out and said that well, you can, right? The goodwill is depreciable, and you should be able to depreciate it. But a lot of transactions popped up in which uh, allegedly this decision was being abused to the advantage of um, taxpayers assisted by creative consultants. As a result, there was a change, an amendment, which sort of plug this loophole, and as a result of which this situation which stands today is that no, you can't claim depreciation on goodwill even if it is taken as a balancing figure in amalgamation. Also, there's one more important question, and I'm not saying that I'm expressing an opinion upon that. I'll naturally charge for it, but the question is that if you are just parking a balancing figure against a title of goodwill, are we really saying that we acquired an asset? Because firstly, the precondition is that there should be an asset, and then we have to test whether that asset is depreciable, right? So even if we forget about the fact that there has been a recent amendment, the question that I'm posing is that just because there's a balancing figure, does it necessarily mean that it represents an asset? I know an economician will say that, I mean, what else, right? What else? But the way I would look at it is that there could be a lot of business efficiencies which are getting created, which is the reason why you are charging a premium, right? But at the same time, it may not necessarily represent an asset, and therefore those are the questions because of which depreciation on goodwill was something which was becoming a bit of a bone of contention. But even if we leave out all the philosophical discussion about have we or have we not acquired an asset, the legal position which stands today is that you cannot claim a depreciation on this kind of a transaction.
Thanks, actually. That was a great answer. And there's another question, actually, that sort of relates to intangible assets, which is oftentimes we see that the location, if sort of the location of intangible property is pegged to the situs of the owner of that property, how would courts approach a situation where potentially a corporation, a multinational corporation, actually transfers ownership of certain intangible assets, for example, intellectual property, to like a holding company registered abroad, and then actually leases that property back from them, reducing their tax burden? So, how would a court sort of approach such a?
It's a good question, Siddharth. It's a good question. See, first of all, I will touch upon the fact that you are in your transaction transferring the IP to your own holding company, right? So it's a group company transaction. So I'll come to that because that's very relevant here. But even otherwise, if you look at the Indian jurisprudence, the Indian tax authorities have mostly frowned upon what we call the sale and leaseback transaction. In this case, it is a license transaction, but essentially a sale and license transaction, right? They're mostly frowned upon it. And unless there is a very strong commercial substance for this kind of an arrangement, because fundamentally speaking, in past, sale and leaseback was a medium to unlock the monetary value of an asset that you already own. It was fundamentally a financing arrangement. So if you look at the financing commentaries, you will actually come across situations where I own an asset, but it's a heavy asset and I need the money too. So what do I do about it? I want to continue using the asset, right? So what would I do? I sell it, and the seller will lease it back to me, but that will unlock a lot of value of the asset. So unless there is a very strong commercial substance, right, backing a sale and license back transaction, there's a high likelihood that even the courts may treat this as a colorable device, right? And I'm consciously using the word colorable device because then I would jump to the legislature car. Colorable device is a judicial car from McDowell days, but the legislative car could also kick in because really, apart from the cash flow movement, nothing else is changing here, right? So it could perhaps potentially result into getting treated as an impermissible avoidance arrangement. Uh, if it's a cross-border transaction, PPT clauses could also be brought into play to challenge what is the reason why you are entering into this kind of a transaction. If you're already cash rich, why do you don't even need the money, the unlocking of the value? But now on top of it, since you mentioned that this is a transaction which is happening with one's own holding company, it's an intra-group transaction. It's a transaction between two associated enterprises, which means that our transfer pricing consideration will also jump in, right? Which requires that in order to transfer price the consideration for this sale and then eventual leaseback, uh, you have to take into account the functions undertaken, the assets employed, and the risks assumed in the DEMPE, the development, enhancement and so on and so forth of those intangibles. So maybe uh, once such transfer pricing analysis is undertaken appropriately, then there is a sufficient likelihood that you might not find any significant tax saving emerging from it. But coming back, uh, in the Indian jurisprudence so far, most of the decisions that we come across in the context of intangibles have not touched really upon the transfer pricing aspect of the intangibles. So, for that matter, even the Fosters and the CUBPTY decisions, they were in the context of taxability, but not regarding the transfer pricing implications thereof. Whereas this is also an important part. So my take on this thing is uh, to answer your question, to summarize all of this in one single sentence, you need to have a really strong commercial argument, right, to back up why you're doing it. Otherwise, you might not be that lucky, and the courts may not look upon it very favorably. The DEMPE analysis will come and bite you hard. Also, taking into account the fact that licenses are also, again, as per the action plan 8 to 10 paper, are also in the nature of a transfer. Yeah. Yeah.
All right, thanks so much. That was a wonderfully detailed answer. So, as an extension of this, what are the potential implications of sort of allowing courts, just regular courts, to be able to sort of deem an asset to exist in a particular jurisdiction? Like, what potential sort of pitfall could there be if this sort of thing is taken to its logical extent?
So it's a loaded question, Siddharth. There are two aspects to it, right? First question is uh, whether the courts should um, so deem, right, an asset to be located in a particular jurisdiction. And the answer to that is really the way the law stands at present. What is the choice? Because the law on situs of intangible, it's pretty much either missing or highly unclear, very nebulous. As a result of which, even the courts, they probably are constrained, compelled to take it upon themselves to go ahead and say that we believe that an IP has its situs in this jurisdiction. That's point number one, right? Uh, Secondly, it's completely undeniable. All the international agencies have always agreed that the potential for abuse, the potential for base erosion, tax base erosion, is so high when you are dealing with intangibles, right? There is significant arbitrage opportunity because of significant divergence in the tax laws dealing with taxation of intangibles. As a result, the first part of the question that fundamentally, is it okay for the courts to so deem the situs of an asset at a particular location? I think really we don't have much of a choice. If they are not doing something wrong, they perhaps have to do that, right? That's something which is called for. Second part, then when they do it, what's the risk? The risk is that it will continue to loom. The uncertainty will continue to loom. The possibility that a transaction which a buyer and seller are entering into, thinking that hey, this IP is located outside India. India only has a limited right to use that IP, and therefore there will be no capital incidence in India when IP is sold outside India to another non-resident by its present non-resident owner. So there's essentially no nexus with India, and yet the Indian courts may deem this nexus by saying that hey, we believe this is located in India, and this is after all what happened in the context of the advanced ruling of Foster's, although they came out victorious later on. And what will therefore be needed is an extremely carefully planned transaction, and a sky-high degree of emphasis on documentation. So if you look at the Australian Tax Office guidance, if you look at again, the ABEX action plan report in the context of intangibles, there is an even incremental emphasis on documentation, which will have to be a burden which will have to be borne by the buyers and sellers. Uh, maybe in this kind of a situation, I would advise my client to go for an advanced ruling. And luckily now, in early this month, there is now a notification that the advanced rulings will get functional again, the board of advanced ruling. So I think probably this will become a practically feasible,
All right. Again, thank you so much. Now, continuing with the theme of sort of intangible assets, what happens when you license an intangible asset to a different jurisdiction? So, what would be the sort of situs of the intangible asset, and where will the same be taxable?
Licensing. See, again, a couple of things. First point will be that is it a related party or an unrelated party transaction? Because the moment we talk about a related party transaction, you know, the entire discussion we just had about if it is between two AEs, then you will apply the Dempe rules, right? You will apply those tests. And the fact that it's licensing and not transfer in a pure play sense of speaking is something which already has been addressed by OECD G20 in their action plan report, where they clearly said that, look, we would treat even licensing as a transfer for the purpose of transfer pricing. Therefore, between these two related parties, there should be ideally an arm's length, consideration which should be exchanged for this licensing, and that arm's length transaction has to be has to meet these tests of FAR translated into DEMPE, right? That's point number one. However, if we are looking at unrelated parties, right, entering into licensing transaction, then it would depend upon the characteristics of that transaction. And let's again look at two completely divergent ends of the spectrum. One possibility, it's a perpetual irrevocable license. If it's a perpetual irrevocable license, come on, it's as good as a transfer, right? Even in Indian domestic jurisprudence, there are case laws where perpetual licenses or leases for 99 years have been held to be as good as sale in the context of land, right? There have been various legal provisions in which lease transactions for more than 20 years or power attorney transactions are treated at par with transfer. So therefore, they will trigger capital gain incidents. But on the other end of the spectrum, if you are looking at genuine cases of licensing where there's a reasonably finite period of the license, there's a fair return of royalty, and that royalty is getting taxed at a reasonable rate now that we are edging towards the G20 or BEPS 2.0 objective of the minimum global corporate tax rate, if it is taxed at a reasonable rate, and maybe the licensor has entered into licensing with a lot of such, licensees, that would probably tell me that, hey, this is a genuine case of licensing. And in that case, my guess is I would say that this is not something which should be subjected to capital gain taxation, irrespective of. So the question of where the situs is will probably not arise.
Thank you. Actually, you've also already largely answered my next question, which was just going to be a follow-up in the sense that could you elucidate the actual process of the DEMPE analysis as per the OECD BEPS action plans, like with a hypothetical example. So what would really be the most important elements of this?
I will not necessarily say that there's one out of all these elements which is the most important element, right? It's actually a combination. So if you look at not just the action plan reports, even in fact, frankly, even the action plan report gives close to 30 illustrations, right? But other than that, also there is a ton of good technical literature which gives a lot of examples on which element has to be factored into how, because it's highly subjective, right? And ATU has been stressing it, HMRC has been stressing it, that document, not don't just say that this particular jurisdiction entity has contributed to the development and that particular entity has contributed. No, nothing like that. Document a ton about it, right? We have been telling our clients that document all the emails and park them into a dossier. Don't wait that some notice will come 3 years down the line and then you'll start this exercise. By then probably half your tax team and 3/4 of your finance team would have got completely replaced and would have been bought over by a startup which is giving a lot of IPOs to their new employees. So the thing is, I believe that you have to look at the relative contribution, right, of each of the constituents of an M&E group towards each of these steps of the DEMPE analysis, right? So, I would love to talk about it more, but then I'm looking at the clock also, and probably this will then become the last question for today. So I'll do one thing. If we have times left over at the end of this discussion, if there are no more questions, I would love to probably explain it in detail, but otherwise, I would point you towards, all those, I guess, 27 or 29 illustrations, right, which you would find in the OECD literature on this.
All right, thank you so much. I'm going to hand off to Supriya now for, I think, the next couple of questions.
Yes, thank you, Siddharth. So, sir, the next question that we have today is that the present legal status of the virtual assets, such as the cryptocurrencies and the non-fungible tokens, that is still very murky. So, can you please throw some light on its legality and what, according to you, is there a need for specific guidelines, policies by the government for its regulations?
Uh, Good question, and you know, uh, quite frankly, I am sort of happy and relieved to sort of say that maybe it's not so murky anymore, right? If I look at the entire way it has contoured up, if I look at the old interministerial committee which had been set up, and that's committee, as I was mentioning earlier, was saying ban all the private cryptos, right? And have a jail term of up to 10 years for anybody dealing in them. My goodness, I was scared that which way are we headed? But the RBI in its 2018 April 2018 circular advised all its bankers, etc., that don't deal with anybody who's sort of providing services for facilitating the crypto transactions, right? But then around 2020 March, the Supreme Court sort of reversed that part, and it came out with a decision saying that, come on, why are you getting so psyched about this? Because there's no harm which is going on, right? So the present status, therefore, is, the way I would put it, is that it's not illegal, right? There's no law which says it's illegal, right? It's certainly not a currency. So cryptocurrency is just a misnomer in the context of most of the countries, apart from a few which have very recently, started treating them in currency, and were not so successful on the couple of days, initial days, because of which the Bitcoin price, not plummeted, went down a bit. But it's not a currency in Indian context. It's an asset class. It's an asset class, and the fact that even the government has started showing its inclination towards simply regulating it, right? And it's a good thing. MCA has, for instance, asked the companies to disclose their crypto trading or investments, right? The government of India is also saying that they also only intend to regulate the crypto trading. The honorable finance minister is saying that we are coming out with a law. The then governor RBI Shaktikanta Das had alluded that RBI is working on its own cryptocurrency. Uh, that is perhaps the reason why we have. I was looking at this data point, but this is probably 3-4 months back. The number would be a far bigger number today. But I remember reading that we have more than 1.5 CR, 1.5 crore investors who have invested more than 15,000 crore rupees in digital assets. This is India, right? So this is the positive side of it. There is, just to sort of draw a contrast, right? I just want to sort of highlight to you that, US Treasury, it listed Bitcoin as a convertible decentralized cryptocurrency. You know how long back? In 2013. We are sitting today 8 years after that, and we are still, sort of scratching our head. God knows what government will write in its, new policy on cryptocurrencies. But that's what, the speed with which government comes out with its policies, particularly accepting a new thing, is something which gives an impetus to innovation. Why is it that Switzerland has something which is called a crypto valley, right? And that is because it is, again, giving an impetus to innovation around cryptos, right? Whereas how many cryptos or blockchain solution do you find coming from India? We guys are some of the most brilliant brains on the planet, and yet so long as the innovator doesn't feel confident about the policy climate, he has only two choices: either to externalize or to think about something else. So that's my take on it. Uh, Also, I would put it this way: the government, I can't completely blame the government that they should not even regulate it. Firstly, psychologically speaking, there is always a fear of change. I have a fear of change. You have a fear of change. Government also therefore fears change, and probably not so wrong, because cryptos do suffer from a fundamental problem that they don't derive their value in a traditional sense, right? They don't have an underlying value creation in a lot of cases. Ether has some good projects and all that, but somebody tell me what is it about Shiba Inu coin, right? Or was it Dogecoin? just because Elon Musk tweeted something, and its value went through the roof. I think its value, crypto's values are very volatile, and they should come with one of those disclaimers that you read for mutual funds, that investments in cryptos are subject to Elon Musk's whims. Please read all his tweets carefully before investing and even after it. Right. So the point that I'm trying to make it is that when you are dealing with these kinds of asset class, also something which is very, very exposed to the possibility of a fraud. Look at Dubai coin. When it was launched, went up like crazy, more than 10 times. And probably in 3 to 4 days, all trading stopped, right? So therefore, my take on this thing is, look, I have a little girl, right? She's 8 years old. So as a parent, I have to always draw a line upon whether I'm doing parenting or I'm doing helicopter parenting, right? I hope you're aware of this expression, helicopter parenting. So that's what the government has to do too. It has to act as a parent when it comes to regulating the cryptos, but not become an obsessive, soccer mom doing helicopter parenting. So that's my take on it.
Thank you so much, sir, for clearing the air with respect to virtual assets. And I'm sure India has a long road to go with respect to these assets. And the next question that we have today is, at present, are the cryptocurrencies taxable? And what is the way forward for taxation of these virtual assets?
Well, about the first question, are they taxable? The answer is hell yes. I mean, absolutely. Look, firstly, the first question was about the legalities, but even if had they been illegal, there's no law which says that if you are earning from illegal means, we will not tax you, because that would become discriminatory against the law-abiding citizens, right? And there are decisions to that effect in Indian jurisprudence. But in this case, since cryptocurrencies are not illegal anyway, definitely any income, any upside that you earn um, from dealing in cryptocurrencies is certainly taxable. Uh, they clearly satisfy the definition of property of any kinds, right? So the only question is, are they stock in trade? Because if they are, then their upside will be taxable as business income. If they are not stock in trade, I mean, depending upon the conduct of the buyer and seller, then they are capital assets. So either ways, the income is taxable. The only question is, what will be the rate and what will be the computation mechanism? That's point number one. But what's the way forward? That's a $1 million question. A bit more than $1 million actually, right? My personal take is that, look, there are countries which are standing on different ends of the spectrum, right? El Salvador, right? Small country in Central America, and it says that, look, we have made Bitcoin a legal tender, and even foreign investors, individual corporations, everybody, even foreign individuals, even if they trade in Bitcoins and earn any gain, here in El Salvador, we won't tax it. On the on a comparatively more balanced end of the spectrum are the ones such as Germany, Hong Kong, um, Switzerland, which say that, look, if they are individuals who are making long-term investments, we will probably not tax them, right? And but if you are doing professional trading or you are a miner, then we will tax them, because then it's your business income. Singapore and Australia have come out with their own respective, guidances, etc. India, I think India cannot afford to let go of even the capital gain tax, because it will again become discriminatory against rest of the asset classes, right? So naturally, India will tax the capital gains bit, and also if it is not a capital asset, then naturally it will tax it the upside as business income. I only hope that they come up with a very clear manner of demarking when is it that the capital gain provisions will apply and when is it that the business profits provisions, or PGPP provisions as we call them, will apply. It's going to be a bit of a tall order. It has tried that in the context of shares, and you know, and it has been a constant tug of war. So let's see how it turns out here. But that's my take on it. Yes.
Thank you so much, sir, for the answer. The next question that we have is that the judgment of the Honorable Supreme Court in the case of Internet and Mobile Association of India versus RBI is a laudable milestone in the virtual currency industry. So, do you think this step by the judiciary would benefit the Indian economy in the long run?
So yeah, I mean that's the decision that I was referring to, alluding to a little while back, March or April 2020. Uh, See, it's naturally it's easy for me to say that yeah, absolutely, it's a great decision, and that's my fundamental take on it, really, right? Yet let me also sort of put the other perspective here. Look at a lot of old school investors. So if you're talking about investing and you have not talked about Warren Buffett, then you have wasted a lot of your time, right? It's like you're talking about design and you're not talking about Steve Jobs, right? It's pretty much sinful, right? It's maybe illegal, I think, right? So if you ask Mr. Buffett that what do you think about Bitcoin, I remember he mentioned something to the effect that it's an unproductive asset. It's not even a store of value, and he said that look, as it is, I'll get into a lot of trouble about things that which I believe I know about, then why the hell should I take a short position or a long position about stuff which I know nothing about? So here, if I look at it, while Mr. Buffett is not very open to investing in cryptos, he actually sort of hates them. Yet he was man enough to admit that it's stemming from his um, ignorance, right? So therefore, if you ask an old school investor, he'll probably tell you that Supreme Court has created a mess out of it. Right? They have allowed an asset class which has no fundamental value at the end of it. Right? On the other hand, if you look, and now on the other hand is a view which I'm a bit of a supporter of, that, and it's not because I don't want you guys telling me, okay, boomer, right? But really, I think if you read what's the Supreme Court decision, it says that there's no proof of any damage, which is what was a concern of RBI when it issued its April 2018 circular. So when there is no damage, then when nothing has been done wrong, then why do you want to stop it? And quite frankly, in today's day and age, if there is no harm, that's my litmus test, that it's good enough. We are, as it is, surrounded by millions of things which harm us, and yet we are living with them. So there's one thing with which there's no proof of harm, so it's good enough. The way I would look at it is that yes, it is going to be incredibly useful to India, provided we know how to promote um, innovation around it. Right? If we are only gonna be punting upon it, then fine. I mean, there will be some generation, but no significant value addition. So my take on this thing is that let's promote innovation around blockchain technologies, distributed ledgers, and yes, cryptos, using NFTs for things other than just selling the videos of Charlie Whitney, which was incredibly amusing to me at a personal level. So that's my take on it. Create education, create policy intervention, but the end objective should be to sort of encourage competition in innovation. Right? That's gonna be the real test for us.
Uh, Thank you, sir. I think I totally agree with you on this. And the next question that we have today is that the present era, which heavily relies on digitalization, so how can an economy avoid the losses that they might suffer due to the trading of virtual assets?
Okay, it's a deep question. It's a deep question, Supriya, because right now I'm interpreting this question in two different manners, and completely two different manners. And it's already 6:30, but I'll probably still, take the liberty to try and answer this question. When we're talking about, you mentioned averting the losses that it might suffer. What kind of losses are we talking about? One part is the losses because of the fact that you don't really know who's trading in, who's dealing in cryptocurrencies, right? And you know what? At one point of time, one of the old school investor, but a heavyweight amongst them, he actually said that I don't want to, I'm not fond of a currency which is so useful to kidnappers and extortionists, right? Even today, if you look at a lot of instances where hackers arm twist corporations, and I'm talking about large corporations, into cuffing up extortion money because they have hacked into their databases and stolen some proprietary information, and they're holding them at a virtual gunpoint, saying that we will release it. There'll be a leak and all this information will be out in the public. Your reputation will suffer a lot. So that kind of a loss is something which in turn is sort of offset by the corporation saying that, okay, fine, we will pay you the ransom, and that ransom, how is it delivered? Through a lot of cryptocurrencies, right? Because of the fact that they are mostly untraceable. That's one kind of a potential loss to the economy that we're talking about. And we really need to up the technology game here, right? We really need to see that why is it that cryptos are going to gain value, and if there are really economic, sound economicians reason about it, we should participate in the game. Look at what China is doing. Apart from the fact that China has said that no private cryptocurrencies, it's actively working on its own cryptocurrency, right? It's only a matter of time that we will also have to compete with other cryptocurrencies using our own government sanctioned cryptocurrency. But you have to build reasons for people to use this as a tender and therefore create a value around it. Right? So that's one part of my, that's the answer to one interpretation of your question, that how do I avert the losses? Second possible interpretation is that what about the losses that may occur if we don't participate? And my answer to that is going to be no, absolutely. Go ahead and participate in crypto transactions, encourage it. And I said earlier, regulate it, but not as a helicopter parent, but just as a loving parent, right? To that extent, educate your investors. To that extent, encourage your innovators. Give real avenues for growth of investment rather than letting people only punt upon something which is going up, and I mean rather than just letting them play upon the arbitrage scale, right? So that's my answer to the second interpretation of your question. Coming from lawyers, I took the liberty of having two completely different interpretation of your question, and I guess at least I address at least one of them address the question that you were asking.
Thank you so much, sir. Please go ahead.
No, I was just saying the reference to actually helicopter parenting actually made it very interesting and clear.
Yeah,
Yes.
right.
Sorry
That
to
is what
clear.
actually, that is what usually is the distinction which has to be told to people who are affectionate towards you, and similarly government, which also has the designated task of being affectionate towards citizens, isn't it?
That's true. Yeah.
So thank you so much, sir. So I believe that participation is the key for us to boost our own economy.
Yeah.
So I'm sure this has brought much more clarity on the topic. And now I request Siddharth to kindly deliver the vote of thanks.
Yeah, hi, Mr. Singhal. Thank you for that fantastic session. It was honestly a pleasure and it was very, very informative. So, on behalf of CCIT, I would really like to take this opportunity to genuinely thank you and express our gratitude. And hopefully, we really look forward to having you again if you would be interested in that.
Absolutely.
And also, can't fail to mention all the participants who joined the session. Without them, this webinar would not have been successful. And on behalf of the CCIT, I assure you that we'll continue to strive for knowledge, and in furtherance of the same, we'll continue to sort of host these expert sessions to ameliorate the lack of clarity a lot of us have regarding taxation and finance. So, thank you.
Thank you so much, Siddharth. It was an absolute pleasure. Siddharth and Supriya, both of you were fantastic. I mean, your questions, usually by this hour of the day, and that too particularly on a Saturday, I am getting into the zone that where I have to pick up my next, thriller novel, because I'm getting into this lazy mode. But you have already thrilled me with, so much of it. I might as well pull out another report and go through it again, right? So great job at your end. Professor Kriti, I'm sure it essentially is coming from all the amazing education that they're getting from you, all the amazing inspiration that they're getting from you, right? Your institution is a stellar one. We actually look at a lot of work that you guys do. Professor Jha, his work is, amazing, inspiring. Even as of late night yesterday, I think, yeah, I was looking at the white paper that you guys have recently released with Amarchand, and I've not been able to go through all of it, but I was going through it. I think I covered only the initial 9 pages. But again, that was on a topic which is very close to my heart, also because it's a bit close to my wallet as well, right? We make a ton of money from advising on digital, transactions issues, but really, you guys are doing a great job in the field of legal education, and sort of combining them with the realities of the commercial world. So, all power to you guys. All power to you guys.
Thank you so much, sir. Thank you so much to everyone for attending. Thank you, sir. Thank you, Siddharth and Supriya, for turning around the session. Thanks so
Thank you,
much.
sir. That was a pleasure hosting you. Thank you. Have a good day.
Thank you. You too. Bye bye.
Bye.
Bye.